The opening minutes reveal a legal battle that is far more difficult than many viewers probably realize. This is not a custody dispute where a judge can simply weigh who seems more caring or more involved.
Case. All
I
right.
didn't want them to have to sit here.
I don't blame you. Adam J. Smith versus Charity Lynn Wheaton Smith then will be reset for the 29th, and then whatever agreement you've made on the interim will.
We have to come back to that.
All right. All right.
So, Ms. Neblett, you've been handed several photos. If you'll look through those photographs for a moment.
This is what I call my sweet baby O. This is my sweet baby O.
So in all of those photos is open, correct?
Yes.
And about what age would that have been?
Well, it looks like this one, I was giving her a bath. We call it a sink bath. So I was giving her a bath in the sink at the house. Probably maybe 6 months, 7 months old at that time. This is Poppy, my husband. This is her, him holding her. This is another one when she was a baby. This was when she was older, maybe a year and a half, 2 years old. This was, I think we were at a restaurant. We would go eat Mexican. This was at the house. And this, I'm not sure where it was, but it might have been at a Mexican restaurant. I don't know. We would go out to eat. Yeah.
Your Honor, if I could submit them all.
All right, we'll mark them as a collective Exhibit 1. Did you had filed your request for admissions, Ms. Roberts, and made mention of the fact they're in the court file. Or were you asking that they be made an exhibit? All right, which we've already established. All right, thank you.
So does that mean the photos are already in?
The photos are Exhibit 1 now admitted. So
All photos that were in the discovery? Oh, okay.
just the ones that you have
Okay,
shown her.
thank you. I appreciate that. All right. I got you. Okay. All right, so during that first 2.5 years of Oakland's life, could you explain to the court how much you were a part of Oakland's life and what type of activities and how often, that type of thing?
Absolutely. During the first 2.5 years of her life, I was very much a part of her life. I would drive to Nashville. They would come to Dixon. We would go out to eat. All of us together, Colt, his mom, his brother, we would all celebrate birthday parties together. I know one, I think it was Mother's Day, we went, me and Colt and Anthony and his mom and the girls, Oakland and Oakland's older sister Willow at the time. We went to Old Charlie's and enjoyed a Mother's Day brunch. It was just like normal, normal family time that we would spend together.
And about how often? Weekly?
Yeah, I would say weekly, for sure. Like I said, I would go up there. This is when they were living in Nashville. They hadn't moved to Dixon yet. And so I would work all day at school, and then I would do my bus route. And then, if they weren't at the house when I got there, then I would get in the car and I would head to Nashville.
Just I'm going to show you one other picture. I think this is when we were
Oakland.
If you could explain to the court what that picture is.
Yes, this was, there was an Easter egg hunt. There was an Easter egg hunt in Nashville, and we had, or maybe this was the zoo. This was the zoo, but I think maybe it was the Easter egg hunt also. We all went as a family. I went, to help them with the kids. So this is Morgan, Colt. Willow is actually on Colt's shoulders, and Morgan, my daughter, is holding Oakland, and I took the picture. So.
Thank you. Could we have this?
Yes. Mm-hmm.
So is it fair to say that at least during those first 2.5 years, you were basically a part of the family? Is that correct?
100%.
And then explain, around 2016, if you could explain what happened at that point.
Things started getting rocky, as I recall. When I say rocky, Colt's and Morgan's relationship was starting to go bad, and they were
I'm
like.
going to interrupt you just a second until the court understands. And who is Morgan?
Morgan is my daughter, Oakland's mother.
Okay, go ahead.
Their relationship started to get rocky, and Morgan was, I feel like it's been so, Morgan was doing her thing kind of, so I was seeing Oakland. I was driving to Nashville at least once a week, and I was asking Colt, when is a good time for me to come up there? I want to see Oakland. And I would go up there at least once a week. And even a lot of times his mom was there with Oakland, and I would even get on the phone and I would say, I would bring them all something to eat, and we would go spend time.
Yes, and I have explained to my client that she cannot give statements of what other people said outside of this courtroom, certainly whatever Colt has said to her, but I think you understand that, so.
I do.
All right, Ms. Roberts has withdrawn her objection after that clarification, so.
So I think you were talking about during this breakup, you continue to still try and attempt, or you did seek Oakland?
Sustained, don't lead the witness, please.
Go ahead.
Okay, so I absolutely tried my darndest to see Oakland. I would call, I would text. So finally, it got to the point where he would not answer my text anymore. He would not correspond whatsoever. I didn't go up there unannounced. I always wanted to make sure that, he was going to be there, but he cut off all correspondence. And from then on, it just, I couldn't see her.
At what point did Colt reach out to you again?
This was probably 3 years later. They had moved to Dixon in Charlotte, and Willow and I, Willow is Oakland's older half-sister. Willow and I were at Jonah's Pizza, and we turned around and we saw Oakland with Colt's mom, and Willow and I looked at each other and our eyes got real big, and we thought, oh my gosh, this is...
One of the most interesting moments arrives before the substance of the testimony even begins. The judge pauses to address a personal concern about recognizing the witness. That brief exchange may seem minor, but it reflects a judge who is actively protecting the appearance of neutrality.
Okay,
We'll let her limit her testimony as to what my understanding was she was thinking, oh my gosh, this is what she thought. So I'll accept it as, can't testify what someone else thought.
I'm sorry.
You can testify what you thought.
Yeah, I looked at Oakland and I was like, oh my gosh, this is Oakland. I haven't seen her in so long. I mean, I was ecstatic. And of course, after not seeing my granddaughter for 3 years, I just rushed to her. I just wanted to hold her. And I know this sounds crazy, but I just wanted to smell of her. I just wanted to smell of her head. I just wanted to breathe her in, I guess. And at that point, Colt's mom gathered their things before Oakland had even had a chance to finish eating, and they left. So it was shortly after that Colt had reached out after he and Allie Kate broke up. He reached out to me and said that he wanted to have Oakland come to family events and that kind of thing and be a part of, the family, and for things to be, like they should be. I was ecstatic.
And during this period of time when you were able to maintain or get back to some contact, for how long did that go on, and when did that stop?
She was approximately 6 until about 9. I was able to see her when Colt said that, we could see her. I could see her. I would meet at the CB store in Charlotte, and I would get Oakland, whenever he would allow that. So that lasted for about a year, and then Oakland got really into ball. And so they were doing a lot of going to, ball games and ball practice and that kind of thing. So in order to see Oakland, I had to see her at the ballpark. And so I would go to the ballpark, Willow and I would go see her play, that kind of thing. She was doing travel ball too. So I would even go to places, far, wherever they were playing. And I was able to see her at that time, like through the dugout. It wasn't quality time, but at least I got to see her.
During that time that you got to see her, did she get to see you as well? I mean,
yeah. I mean, we would like she would come to the dugout fence or whatever, and we would have a drink, and me or Willow would stick the little straw through the dugout cage so that she could get a sip, and wave hi, and I would try to get a picture.
Did you attempt during that period of time to see if you could get some other kind of visitation other than just at the ballpark?
I would always text and say, or call, I would even call her on the phone, and I was able to call her too. But I would always text and say, I would love some quality time with Oakland. I want us to go and get our nails done. I want me and her sister to go, have a pedicure, go out to eat, go shopping, that kind of thing. But it was always kind of shut down. They were always too busy.
And then did there come a time when you were shut off completely? Explain to the court if anything happened down the road when that all stopped again.
So what happened was when I wasn't able to see Oakland for just at the ball games or whatever, me being a bus driver, at the end of the year in May, they always call it that's the field trip time of the year. And so Oakland's class was going to go to the Adventure Science Museum in Nashville. So I jumped on the opportunity to drive for the field trip. So me and another bus driver, we got there at Charlotte Elementary, and I was parked around back, and I was waiting for the classes to come out. And so Kristen, who was Colt's wife at the time, she had gone in the building, and I wasn't quite sure why she was there. Next thing I know, the kids start to come out of the schoolhouse and to go get on the bus, and Kristen got in the middle of the parking lot and raised her hand up in front of the classes and the children and said, "Objection, hearsay." Oh,
Your
I'm
Honor,
sorry.
that's fine, because we're going to have Kristen testify to this. Let me just ask you
I'm
this.
sorry.
No, that's okay.
I was just telling
You're
them.
doing great.
I'll sustain the objection, but I would remind you that hearsay is a statement made outside of the courtroom being introduced to prove the truth of what is said in that statement. So not every statement made outside of the courtroom is hearsay if it's not being offered to prove the truth of the matter. But since you have the witness here, let's move on.
Thank you, Your Honor. Let me just ask you this, without saying or stating what was said. Were you prevented from, were you,
Overruled.
was there any indication that there was a no contact now between you and the child?
Yes. I was told that I was put on.
Did the school resource officer prevent you
When there's
from
an
seeing?
objection, let me rule on the
Oh,
objection.
I'm sorry, Your Honor.
Sustain the objection.
Did the school resource officer prevent you? I haven't even finished my question yet, Your Honor.
Let him finish the question.
Were you prevented by the school resource officer from seeing Oakland?
Yes.
I'm going to overrule the objection to that particular question.
Thank you, Your Honor.
Can I say it was just at that time?
It's fine. You've done well. You set it up. When was this? What, do you remember the date?
It was May of 2023 or 20, it was May. I think she was 9. So May of 2024, maybe.
Is that when,
or
by the way?
23. I can't.
Yeah, that's all right. In the record, there are a few nasty text messages from you. I think something about referring to the father as a fucking child abuser.
I did.
When did that happen and why did that happen?
Well, after that happened, after I realized that I was on a no contact list, I had never known this up until that date. And I had never responded in anger Oakland's entire life until that day. And that's when I responded in anger. I think at that point, I was emotionally torn apart and distraught, and I did text in anger. I did.
Why did you take this legal action?
I took this legal action because, well, I mean, I want to be a part of my granddaughter's life. I want her to know her Omi. I want her to know her Poppy. I want her to know her family. I want her to be able to see her sister, Willow. In my mind, I think the best thing ever would be me and her and Willow cuddling up on the couch and watching a movie together. I want to be a grandmother, and I want her to know.
The grandmother's effort to prove the existence of a meaningful bond rather than a casual family connection. Her testimony paints a picture of someone who was deeply woven into the child's early life through routine contact, shared celebrations, travel, and family activities.
That her Omi loves her with all of her heart.
Explain
And
to the court, who is Willow?
Willow is one of Oakland's sisters.
Uh,
Willow is Oakland's sister,
and who is the father of Willow?
Daryl Miller.
And your daughter is the mother, correct?
Yes.
Do you know where is Willow now? Who has custody of Willow?
Daryl, her dad. Primarily.
Do you have visitation with Willow?
Oh my goodness, Willow has her own room at our house. I see her more than.
Well, Your Honor, when we talk about the best interest of the child in this particular case, I want to show that, and also when we talk about substantial harm, I want to show that the grandmother is in no way harmful, and plus she has a great relationship with Willow, who is the half-sister of Oakland, and because of all of this, the two of them have been separated as well. It kind of goes to how this is damaging to Oakland as well.
I'm going to overrule. I'm not, again, sure that this testimony is fitting within the criteria of the statute, but I'm erring on the side of allowing it in to allow you to present your case, but remind all the parties that I'm bound by the strictures of the statute in order to make this decision. So overrule the objection.
I thank you, Your Honor. Do you have other grandchildren?
I have our stepson and his girlfriend just had a little baby, Palmer, and I actually watch her while they work. She's
Have you ever
old.
been accused of any type of crime?
No,
Do you abuse alcohol?
no,
Do you take any illegal drugs?
no.
I,
Unlike a custody arrangement where the court is required to consider the best interest of the child and look at the background and so forth, the first step in this case is to determine those statutory factors. So I'm going to sustain the objection as to those questions.
I understand, Your Honor, and I was just going to the final in the statute, when it does talk about best interest, I just wanted to show the court that the child would not be harmed in any way. But that's fine. I will move on. So finally, Ms. Neblett, as you've probably heard now, the banter in the statute and the understanding of all that, could you explain to the court why you should have visitation? And could you explain to the court why you feel that Oakland would suffer if you continued not to have visitation?
What sticks out in my mind is when I did have Oakland one time, she was going through my phone, and I'm a big picture person, and she said, Omi.
The objection,
I want Oakland to, I'm sorry.
the objection is based on relevance? Okay, you're about to repeat what your granddaughter said about that, so I would have to sustain the objection.
I'm sorry.
Well, Your Honor, though, this is not for the truth of the matter told. Then the relevance is how strongly the grandmother feels about this and why she brought the suit to begin with.
And which is not, it doesn't matter whether the grandmother feels, I take full understanding that Ms. Neblett has brought this matter because she loves her granddaughter and wants to be a part of her granddaughter's life. But the statute that I'm dealing with does not have a factor that how strongly does the grandmother feel. That's not a part of what I have to decide. So I have to sustain the objection.
Thank you. Yeah, once again, without any hearsay,
I can.
if you'll explain to the court, why should you have visitation?
I can. I should have visitation because I want Oakland to know me. I want her to know our side of the family. I don't want Oakland to feel uncomfortable. Dixon is a small town. Charlotte is a small town. We're going to run into each other. We're going to see each other, and we have. I want her to be comfortable coming to her grandmother. I want to be comfortable going to her. I want to be able to say, I love you. And I want to be able to say, I'll see you soon. If you need Omi, Omi's here. I want her to know that she has an Omi and a Poppy and a family that love her unconditionally and that she is loved.
Thank you. I have no more questions, Your Honor.
Ms. Roberts, you may cross-examine.
Your way of doing that is sending him a text message saying you're a fucking child abuser. Is that right?
No, ma'am.
But you did do that.
Yes, ma'am, I admit
And
it.
your husband threatened to physically harm him, correct?
That was a conversation.
Correct?
That was a
Answer yes or no, please, ma'am.
that was a conversation.
Your Honor, could you direct the witness to answer yes or no if she can explain?
You must first answer the question you're asked, and then if you need to clarify your answer, you may do so. But
Yes,
you
he
gotta-
said that.
And that's not the only, he's not just said that one time, he said it multiple times.
No,
Is that
ma'am.
correct?
No, ma'am.
And you have sent vulgar and inappropriate text messages a number of occasions, haven't you?
No, ma'am.
Just one time is your testimony here under oath?
There's only one time I can remember, yes, and that was that incident there at the school.
And again, the way that you've couched that is that you found out that Oakland's class was going to the Adventure Science Center, the Children's Museum,
Yeah,
and that you asked and said you wanted to be one of the bus drivers.
absolutely. I always let the bus garage know when I tell them, if a field trip comes up, either at Charlotte Elementary or Charlotte Middle, let me know so I can drive for my granddaughters.
Okay.
Yeah.
Did you ever contact and ask permission to do that with the father?
The hearing begins shifting from relationship history into conflict history. The school field trip incident becomes important because it marks the moment the grandmother says she realized she had effectively been cut off. What stands out is how carefully the court polices the testimony.
I didn't feel I had to ask permission. I didn't know I was on a no contact
Well, how did you find out you were on the no contact list?
that day. The day of the field trip.
You just weren't on the pickup list, correct? There is no contact order in existence, is there?
I'm worried about saying, well, when someone throws their hand up and says she can't get on your bus, you're on the no contact list.
Have you been provided a no contact list?
No,
Have you been provided any order?
never.
Okay.
I had no idea, which is why I took the trip. I was excited.
And was it your intention to go behind the father's back to have contact with Oakland?
Well, going behind his back, well, absolutely not. I had no idea it was on a no contact list. I was excited to go on a field trip to see be with my granddaughter.
Okay.
I saw it as
And
a
then you got
wonderful
angry-
opportunity.
You got angry about that and then sent this.
Oh,
Your Honor, I asked the question. That's already been answered.
I did.
Well, this is cross-examination, so I think she's entitled to ask the question in the manner she wishes. Overruled.
Not just, I'm angry, I'm upset, you're mean, you're hateful, you accused him.
I did. I was angry. I have been dealing with this for all of Oakland's life. I finally I was just so distraught.
And again, as your counsel said in opening arguments, and I want you to ratify, the purpose on you doing this is so that one day you can go to Oakland and blame her father.
I'm not blaming anyone. I'm not blaming anyone. So what I want to do, and the purpose of this, if this doesn't work out for me to see Oakland, I want her to know one day that I did everything that I could possibly do to see my granddaughter. And she'll know one day. But this has nothing to do with me blaming Colt.
And how old is your granddaughter today?
Oakland she should be 11.
And you have not had any contact with her in the past 3 years, is that right?
Since that field trip.
And which was when?
May, and I think it was was it 23, May of 2023?
22?
No, 2023, so it's been 3 years.
3 years.
Mm-hmm.
And prior to that, you went to ball games and visited her at ball games and things like that.
I did. I went to ball games and watched her play. Willow and I would go see her play. And before that, when it wasn't a ball game, like I said, I would meet them at Charlotte Middle, not Charlotte Middle, but the CB store in Charlotte, and kind of like the meeting place. And I would get Oakland. I never heard that conversation. I think that was between my husband and Colt. I sent the text. I've admitted that. I never heard the conversation. But, I mean, that was, like I said, that was between him and Colt.
What grade, do you know what grade your granddaughter's in?
She's in 5th. She'll be at Charlotte Middle next year.
She plays sports?
Yes, ma'am. I keep up with her as
You
best
do.
as
You
as
keep
best
up
as
with her.
as best as I can.
And you know she's got a circle of friends?
Does she?
Well, you keep up with her, that was your testimony.
I don't know about her friends,
Okay.
but I do. I try to keep up with knowing did she love ball? Yes, she loves ball.
And doing well in school, do you,
As far as I know, she's doing great in school.
and how would you, and again,
I
as far as
would-
you know?
Well, I mean, I wouldn't have anything. She's smart, from what I remember.
You ask
she's-
questions of teachers and different people.
No, I do not.
You don't?
I wouldn't know. I don't know any of her teachers.
Well, yeah, your testimony was, I keep up with her. And so my question
if I
is, in what way you keep up with her? Do you say, hey, did you see Oakland? How's she doing?
You know what? She actually, there's a little girl on my bus that plays ball with her or used to play ball with her, and she'll tell me about, I saw Oakland the other day. Oh, did you? Where'd you see her? That kind of thing.
That kind of thing.
Yeah.
And so that she's held in high regard to that young lady?
Who is held in high regard?
Your daughter, Oakland, she comes up and tells you, this young lady on your bus says, oh, I saw Oakland Day, and you'll ask, oh, how's she doing? And
I do. I said, where'd you see her?
for
Yeah.
all practical purposes, the information that you got appears that Oakland's doing well.
I mean, as far as a child says, you know, a child's version of, yeah.
And you don't have those conversations with adults?
What adult would I have the conversation
I'm
with?
asking you, ma'am.
I don't know of any conversation I would have with an adult.
Okay, so you do not, sitting here today, you don't know whether Oakland's well-adjusted or if she's having issues or anything like that. Is that correct?
I don't know where you're leading that. I
And
mean,
you don't have to know. You just answer my question. Sitting here today, you cannot give any shred of evidence to this court saying that Oakland is in any way, in any type of harm, can you?
if I tell you, it's hearsay. Right? So you just got on to me for hearsay multiple times. I can tell you, but it's hearsay. So I can't do that because I will be shut down.
But what
Right.
harm do you know that Oakland is suffering by not having visitation? Not speculation, not conjecture. What harm do you know that Oakland is having
Okay.
that falls on her?
I'll give you an example. So I was a RBT, which is a registered behavioral technician. My client was a student at Charlotte Elementary. I would work through a company called No Boundaries. So I would go to school and I would see Oakland from a distance.
And when was this?
This was probably 2 years ago. So I would see Oakland from a distance. There was one incident that sticks out in my mind, it was an assembly, and I was in the gymnasium with my client, and the Oakland's class was getting an award or something, but they were walking around, and she saw me in the bleachers, and I saw her, and we looked at each other, but she didn't talk to me. I don't know why. She didn't talk to me. She's been directed not to talk to me. And
You
so,
don't know that.
okay, but
Do you?
so,
This portion reveals a growing tension between what the grandmother wants emotionally and what the court requires legally. Her testimony centers on identity, belonging, family heritage, and the desire for the child to know her relatives. Those goals are understandable and compelling on a human level.
I was on a no contact list, so I mean, I didn't know if she knew that too. So anyway, she looked up at me and kind of cut her eyes up at me, and I looked at her, and I can remember mouthing, "I love you." And she looked at me and she smiled, but she put her head down and just kept walking back up the bleachers. So I tried to reach out to her in that way, just letting her know that I loved her, even just by mouthing the words. But I was never able.
So the answer to my question is you don't have anything to show that she's in harm's way right now. There's any significant emotional trauma befalling that child, do you?
It would be hearsay.
Your Honor, since she's been asked the question, she should be allowed to
No.
answer
Can
it,
I ask-
even if it is
I
hearsay.
can.
Ma'am, if there's an objection, you need to be quiet while I hear it. What are you saying, Mr. Mize?
Well, my client is in fear of hearsay, though by answering Ms. Roberts' question, I'm just saying that she's allowed to answer the question if the question itself is asking for hearsay.
Your Honor, I was asking for personal knowledge, not of speculation, conjecture, innuendo,
Can I answer your
of
question?
her personal knowledge.
Personal knowledge does not include hearsay statements, so I would overrule your objection. She's only limited to testifying. Statute requires there being some proof of substantial risk of harm to the child, and I think what Ms. Roberts is asking is what evidence has Ms. Neblett, what can she produce that would show that substantial risk of harm or injury?
3 people have come to me, if not more, and have told me that Oakland is in physical and mental harm. And I do have proof of that. So this This is what is encouraging me to drive forward for Oakland. I do fear for her.
Because she's not seeing you.
No,
Okay, that's all. Thank you.
Redirect?
Yes, Your Honor. Just on a couple of things that Ms. Roberts just covered, she was talking about, and we're trying to establish how Oakland would benefit and maybe suffer if not having direction. Going back to the gym and your description of that particular moment, though she didn't speak to you, what did you observe that indicated to you that she did want to?
There's a substantial list of objections, and I think you're asking her to interpret the reaction that the child had and in some way interpret that, which would be entirely subjective. Sustain the objection.
Thank you, Your Honor. And then just to one other thing, at the very end, you were asked, the substantial harm now that you're in fear of is because you have had indications.
Sustain the objection, don't lead the witness.
Could you explain one more time what you were saying at the end?
Yes, I've had multiple people approach me that Oakland is being abused. I have picked.
Well, she can't repeat the statements, but she's listing statements from other people that is the basis for her concern or fear. But those statements are inadmissible. She can say she's had statements made to her, but then it doesn't carry any weight as far as meeting the requirements. Overrule the objection.
Thank you, Your Honor. So without stating specific statements made by others, why are you concerned?
I was so concerned at one point that I did a welfare check. I was concerned. I did a welfare check because I was so deeply concerned from the pictures that I had received from someone.
That's all I have.
I wanted to, since I have to make this decision, I would like to ask a couple of questions myself. Primarily, it has not been mentioned other than the fact that your daughter Morgan is nowhere to be found in this hearing. Why is she not here today? Do you have any idea?
I've asked myself so many times, why? And
Well, what is the nature of your relationship with your daughter?
my relationship with my daughter is good now. It's good. For the longest time, though, I didn't talk to her. She made a very bad decision years ago when the girls were little. And she made the decision she met a man and she moved to Ohio. And she left the girls here with their dads. Willow, I have a wonderful relationship with her.
And I'm really just,
Oakland, I've tried so hard. And
so listen to the question I'm asking.
okay, I'm sorry.
Your daughter is not here. Where does she live now?
She's in Nashville.
In Nashville?
Yes, sir.
And does she have any contact with Oakland?
No.
So she has no court-ordered visitation?
Can I speak to you freely without being worried about what to say?
I'm asking the question, so yes.
So Morgan still has visitation. From what I gather, Morgan is very intimidated by Mr. Riddle. And so she is worried about the trying to reach out to Oakland.
Well, my question is, if you can understand,
I'm trying.
if Morgan has visitation with these children, with Oakland, then what is to prevent you from having contact with your granddaughter through Morgan's visitation?
She doesn't ask for the visitation. She doesn't
She doesn't see
pursue
her?
it. No, she doesn't pursue
Okay.
it, which is why I'm having to do this.
All right.
Sir, can I say one more thing?
No, I'm sorry. My questions are those questions that I have to ask, and it's not an opportunity for you to volunteer information. I apologize. All right, Mr. Mize, anything based on what I've asked?
No, Your Honor.
Ms. Roberts, anything based on what I've asked? then step down if you will, please.
Yeah.
Mr. Mize, you may call your next witness.
Yes, my next witness is Kristen. That's right, Kristen Riddle. I think she's out in the hallway.
The defense now attacks the most vulnerable part of the grandmother's case, proof of harm. This is where the hearing begins turning decisively. Questions move away from past relationships and focus on present realities.
Seen the grandchild has at least seen her and drops her head. And finally, the court must determine if it's in the best interest of the child to have the relationship with her grandparent. I knew none of my grandparents. Both my grandfathers died before I was born. My two grandmothers were in Germany. I met one grandmother one time when I was 7 years old. I would give anything to be able to have that relationship. But I couldn't. In this case, it's possible, but it's been blocked. As you can probably well see, and I know that this court already in its responses knows that this grandmother loves her grandchild deeply. And it's even more hurtful that there were times when they were able to establish this very strong bond, and then it was taken away, and then brought back, and then taken away. That is substantially harmful to the child. And I would ask, as I said before, my client's response is, I want my Oakland to understand that I did everything that I could. So there it is, Your Honor. Thank you.
This court is bound by the language of the statute and the requirements that are set forth, and by the case law interpreting those. So I'm going to take a short recess and look at some case law on this point, and you have something you wish to submit. All right, I've reviewed the authorities and the statute and prepared to make my ruling, but let me preliminarily first say this. I'm a grandparent. I have two biological, I have three biological grandchildren, and I have 4 step-grandchildren, 5 grandchildren. I have a total of 8. And every week I have some contact with them, and I believe it is in their best interest to have contact with their grandparents and so forth. So I'm a firm believer in the fact that grandparents contribute a lot. Like Mr. Mize, I had very limited contact with my grandparents. My grandmother died when my mother was 6 years old, and I never got to know my maternal grandmother at all. My grandfather on that side was an elderly man from as long as I ever knew him, and he was a farmer, and then he didn't live long past my high school days. So I really had very little interaction with, on my father's side. My grandparents were country folks and lived in Sardis, Tennessee, or Saltillo in Hardin County, and I had very little contact with them. Contrast that with my children and the interaction with my parents, who are their grandchildren, and I think it definitely was a beneficial effect on them. So I am a firm believer in the fact that grandparents should have a relationship with their grandchildren, and that grandchildren and children in general benefit from that. But my personal beliefs are not the controlling issue in this particular case. And has been pointed out by Ms. Roberts in our Tennessee Supreme Court, and I'm reading this into the record because I want the parties to understand the restrictions that are placed on the courts in determining these cases. Our Tennessee Supreme Court has said that the right of a parent to raise a child is a fundamental liberty interest protected by the 14th Amendment to the United States Constitution in Article 1, Section 8 of the Tennessee Constitution. They're referring to that in Hawk versus Hawk, which is 855 Southwest 2nd, 573, a 1993 Tennessee Supreme Court case. Parents' rights to the care and custody of their children without undue governmental interference is among the oldest of the judicially recognized liberty interests protected by the Due Process Clause of the federal and state constitutions. I'm skipping on down to some of these rulings. Neither the legislature nor a court may properly intervene in parenting decisions absent significant harm to the child from those decisions. The substantial harm requirement protects parents from unwarranted state interference in the parenting process. Absent substantial harm to the child, a trial court lacks a sufficiently compelling justification for interfering with the parent's privacy rights by ordering grandparent visitation. The substantial harm component has thus been described as the threshold question in grandparent visitations cases, and that's citing the McGarity versus Reynolds case, which is a 429 Southwest 3rd, 562, 570 Tennessee Court of Appeals decision in 2013. The decisions of the United States Supreme Court and Tennessee Supreme Court interpreting the federal and state constitutions explicitly prohibit any judicial assumption that grandparent and grandchild relationships always benefit the child as contrary to the parent's fundamental right to raise their children. And that particular provision hit me hard because I do tend to think that I do presume that a grandparent-grandchild relationship is in the best interest of their child. But as our Supreme Court and United States Supreme Court, my belief cannot be applied in this case to render a decision that is contrary to the law. So when looking at the statute that we're faced here, the first step is to determine whether or not there's even a grounds or an application of the statute. And the court does find that the statute would come into play because under that statute it says that any of the following circumstances when presented in a petition for grandparent visitation goes on to talk about if the grandparent visitation has been severely reduced by the custodial parent or whatever, that subsection 2 of that is that the child's father or mother are divorced, legally separated, or were never married to each other. And it goes on to talk about other factors that could come into play. Clearly, these parties, the biological parents of this child, were divorced and are not together, and as a result of that, the statute would have application.
The judge's questioning becomes one of the most revealing moments in the entire hearing. Instead of focusing on emotions, he starts examining practical alternatives. His questions about the mother expose a critical weakness.
But then in subsection B1, it says, in considering a petition for grandparent visitation, the court shall first determine the presence of substantial harm to the child. Such finding of substantial harm may be based upon the cessation or severe reduction of the relationship between an unmarried child and the child's grandparent if the court determines upon proper proof that A, the child had a significant existing relationship with the grandparent, that a loss or severe reduction of the relationship is likely to occasion severe emotional harm to the child. It goes on to say, subsection B, that the grandparent function as the primary caregiver such that cessation or severe reduction of the relationship could interrupt provision of the daily needs of the child. That doesn't apply in this case. Subsection C, that the child has a significant existing relationship with the grandparent and the loss or severe reduction of the relationship presents the danger of other direct and substantial harm to the child. Clearly, there's been evidence in this case that there was a relationship between Ms. Nevlin and this minor child, and that up to a certain point, she had regular contact with the child and had a beneficial relationship with the child. That relationship ended, and there's really no proof before the court as to why that relationship ended or why the father, Mr. Riddle, made the decision to terminate that relationship. Obviously, the biological mother is not present and therefore has very little impact in this decision. But there's really no proof before the court as to why this relationship was terminated or why it ended. But it was terminated, and there was a finding, or is a finding by the court that relationship ended. So what do I have in the way then of any proof of substantial harm or injury to the child or danger of substantial harm or injury to the child? And essentially what I have is the fact that Ms. Neblett is a grandparent who loves her granddaughter, had a good relationship with her, and wants her to have an opportunity to know that side of the family and to have a relationship with her biological sibling, and that she fears that that's going to be a detriment to the child in not having that. Unfortunately, this court's finding research that I have conducted in this case indicates to me that that does not rise to the level of a substantial harm that the statute would require. And I'm going to refer to some findings of the Court of Appeals in the McGarity versus Gerald's, which is cited already. It's the 429 Southwest 3rd 562, a 2013 Court of Civil Appeals case. And in that instance, the trial court granted the trial court granted the grandparent visitation based on the fact that there was two instances that indicated that the child had a good relationship with the grandparents and might have been upset about seeing the grandparent or hearing the grandparent's name. They went on to state that essentially there are only two instances regarding this child supported by evidence in the record that grandparents used to support their harm argument. First, the grandparents point to the testimony of witnesses to a number of exchanges between grandparents and appellants prior to the cessation of visitation. The witness testified on numerous occasions the child cried when grandparents returned the child to the appellants and indicated he did not want to leave the grandparents' care. Next, another witness testified she saw mother and child at a retail store after the cessation of visitation. When the witness asked the child about grandparents, the child became excited and repeated the name Nana, which is how the child refers to Mrs. McGarity. But the court went on to say there was no evidence in the record that the child suffered any ill effects due to the cessation of the grandparent-grandchild relationship. In this case, there is no evidence before the record that the child in question, Oakland, has suffered any ill effects or trauma as a result of the cessation of the visitation between her and the grandmother. Instead, again referring to McGarity, it says, instead the evidence showed only that the child became excited at the mention of the grandparents, not that he became inconsolable or otherwise upset due to the loss of connection with them. Feelings of excitement do not rise to the level of other emotions of embarrassment, anger, chagrin, disappointment, worry, or nausea. There is simply no evidence in the record to support a finding that the child will likely feel inadequate, abandoned, rejected, or that he will lose connection with his heritage, or that he will suffer economically if visitation is not granted. The court in that McGarity case simply found that the cessation of visitation, it was not shown by the grandparents that the cessation of visitation is likely to have any substantial harm to the child. In this case, I would love to be able to find that there is a basis for awarding grandparent visitation, but the statute does not allow me to do so because there has been no finding that there is a substantial harm to the child by the cessation of the relationship, or that there's likely to be a substantial harm. It would be my hope that perhaps the biological mother can get her act together and have regular visitation, and that somewhere along the way that would allow Mrs. Neblett to then begin to have a relationship with Oakland again through her visitation. But in this court's finding, the petitioners have simply failed to meet the burden, the threshold question, and therefore the court finds that the petition should be denied.
The ruling illustrates a judge separating personal beliefs from legal obligations. He openly discusses the value he sees in grandparent relationships and even reflects on his own experiences. That honesty is significant because it removes any doubt about his personal sympathies. Yet the ruling ultimately demonstrates why judges cannot decide cases based on personal preferences. He carefully walks through constitutional protections, appellate precedent, and statutory language before reaching his conclusion. The key turning point is his determination that evidence of a loving relationship does not automatically equal evidence of substantial harm. The grandmother successfully proved affection, history, and commitment. She did not successfully prove that the child would likely suffer the severe emotional injury required by law. The final decision is less a rejection of the grandmother herself and more a reminder that family court often operates under legal standards that are much narrower than common notions of fairness.